Hello and welcome to this webcast. Feel free to ask your questions during the presentation by entering them in the space provided. They will be answered after the presentation. We wish you a good webcast.
Good morning, and thank you for joining us this morning. We'll be talking about Bill 96, which amended, amongst other things, the Charter of the French language here in Quebec. We held a similar webinar early in the summer, right after the bill was enacted on June 1st, 2022. 4 months down the line, we've had time to reflect on the application and scope of this broad spanning act a little more, and the new provisions have come into force in the meantime, so we'll be talking about those as well. So my name is Pascal Lauzon. I'm a partner with the IP group, and I will be talking about labeling and signage as they relate to trademarks. Eleonora Giuseppe will talk about banking, financing, and real estate law. Sean Finn will be talking to us about more the litigation aspects, and Nancy Boyle, labor and employment. Before we start, note that we will be taking questions at the end. We've reserved a half hour to that effect, so please feel free to type in your questions as we go along, and our team will flag those that are more relevant and more well, a lot of the same questions pop up. So if your question is not exactly the one that's being addressed, it's likely part of the bunch of similar questions. So with no further ado, trademarks, signage, and labeling. So I'll start just with where we are now and where things are going, because these provisions, these new provisions won't come into effect before June 1st, 2025. So people think that they have a long time to not think about it, but as we'll see, it's a little more complex than that, and it's better to address these issues now in order to be ready. As you know, like for example, a sign. If you put up a sign on your store, you don't want to take it down in 2.5 years if you've invested a few $1,000s in it, for example. So as a general rule, as you all know, in Quebec, labeling for products has to be in French. It can be multilingual, pardon me, as long as no language is more dominant than French. For example, we see, typically in Canada, because there's the federal legislation too that imposes the use of both languages. People tend to forget that, but it's also relevant. So we typically see English, French equally on our consumer products. Sometimes we see English, French, Spanish because it's part of the North American market, and sometimes we see European labels that have like 5-6 languages. And I had a case once where it was like a European label which was French, English, German, Spanish, and Italian, but the English was bigger, and the 4 other languages were like underneath. And the Office Québécois de la langue française took issue with that, and it had to change so everything was on the same foot. And for signage, the general rule is also that public signage needs to be in French. Public signage on the premises of a business can be in French and in another language, if as long as French is markedly predominant, which is normally interpreted as at least twice as big. And the regulations provide for many exceptions where no other language is permitted, and where French doesn't need to be markedly predominant, but we won't get into that. Now, coming to a very important exception, which is the one we'll be talking about most this morning, is the exceptions regarding trademarks. And I'm talking about the law as it currently stands and as it has over the past years. So that is a trademark recognized under the Trademarks Act can be used, even if it's not in French, on labeling and public signage. And by trademark, it's been interpreted as meaning a trademark that doesn't necessarily need to be registered. It could be just, as long as it falls within the definition of a trademark in the Trademarks Act, that's good. But there's an exception to the exception. And if you have a French version of the trademark that's registered, then you're not entitled to the exception of using a non-French trademark. So typically, clients come to us and they have like a French trademark and an English trademark, and they want to, file an application to register both. And typically, we'll say, well, if you want to benefit from this exception, just go with the English version and use the French version at will, but leave your door open to use the English one. And that also brings questions, because it's not because necessarily you have two trademarks, a French one and an English one, that one is a version of the other. And an example that comes to mind is the office supplies chain at Staples. Now, Staples in French would be Agrafe, but in Quebec they're known as Bureau en Gros, which is arguably not a translation or arguably not a version of the English trademark. So I guess, you could still have two versions, maybe use a different word, but and keep your right to that exception. Now, so that's just the basic, situation as it is now. And what will be changing, most importantly, as of June 1st, 2025, is that to benefit from this exception, the trademark will need to be registered. And so that seems fair, at first glance, but that raises a lot of problems and issues. The first one being that it requires, in Canada right now, the backlog with the Trademarks Office is so huge that it takes at least 3 years to get a trademark registration, and that's when everything goes well. So as I mentioned earlier, the deadline, the coming into force seems far down the road, but 2.5 years from now is shorter than the time required to get a registered trademark. So that raises the question: will there be some leeway by the Office québécois de la langue française on tolerating the exception while a trademark application is pending, and if so, for how long? Because even if you file a trademark application and there's an objection and later an opposition, and the opposition gets appealed and it gets appealed again and it gets all the way to the Supreme Court, it could take 10, 12 years to get your registration. So that's something to think of. And also, not all trademarks are registrable. There are provisions in the statute that need to be met. And so thinking about adopting a trademark that has a high risk of being quickly registered would be a good strategy. Another problem, and as you'll see, I'm raising more problems than giving solutions here. And the reason being is that the regulations for the language of, hold on, I'll just give you the proper title of it. It's the regulation respecting the language of commerce and business, which is presently in force, deals with the act as it now stands. And there's currently no actual draft or proposition for a new regulation that would provide for the exceptions that could apply and give us some interpretation on what several of the terms actually mean. So the third example, the third problem that the exception raises, because as I mentioned earlier, currently, if it's a trademark, it's in the exception. Now it's a registered trademark. But as you may know, a registered trademark doesn't cover everything under the sun. It covers a list of specific goods and or services. So let's say I have a registration for coffee cups and I use my trademark on it, then I'm good and it's registered and fine. But then what happens if I want to sell beer mugs or just cutlery and it's not in my registration? Will I be forbidden from for benefiting from the exception because it's not covered in my application? And again, it takes several years to get that in there.
You could always sell your beer in your coffee mug.
Yeah, we could drink beer in the morning.
I like how you think. She's Irish. You can tell. We can tell.
So that's with and that applies both to labeling and signage. So if we look at signage more specifically, no, wait, hold on. We'll go to the labeling first. So a new provision that will be coming into force is that if there's a generic or descriptive term, related to the product at issue within the trademark, then that has to be in French. And the reason behind that is because there used to be some businesses would try to broaden the scope of the exception by filing trademark applications that would cover the entire label. It would be in English, in Spanish, or Italian, or whatever. And then they'd say to the Office québécois de la langue française, listen, I have a registration for this, so I'm good. So to circumvent that circumvention, the new act provides that generic terms and descriptive terms need to be in French. And that raises a very serious constitutional issue for two reasons. The first one being the Trademarks Act, when you have, which is a federal legislation, when you have a registration, the act grants you the positive right of using that trademark. So it's not only a shield to defend yourself or against infringement, but it's also a positive right to use a trademark from Newfoundland to British Columbia. And so the Quebec law that would forbid the proper use or whole use of the trademark as registered would come into conflict with the federal law. And as a basic principle under Canadian law, when there's a conflict between provincial and federal laws, the federal law prevails. And also, according to the Constitution, trademarks are federal jurisdiction. So is Quebec legislature authorized or within its jurisdiction to adopt such legislation is a very serious question. And in our community, in the IP community, and this is highly debated, and we're likely to see contestations on that, but don't bet on it right now, as you never know.
Pascal,
yes.
Sorry, have you seen any practical implication of this as of now? I know that the provisions are coming into force later, but have you seen cases where you've had to think about the consequences of this act for clients?
Well, yes, actually, we need to think about it all the time, because when you come out with a product or open a store or an office, you're not thinking just hopefully your business will thrive, and you'll want to continue. So you don't want to. So although the provisions are not enforced now, we're seriously considering them and recommending to clients to abide by them. But as we could see, there's a lot of gray area. So do we want to bet on a narrow interpretation, or we want to go safe and go for a broader interpretation? So that's where we are now. And an example. A real live example, we have a client that's opening a store in Bromont, which is like a ski, alpine ski area, or mountain bike, and they're opening a store, and the city did not give them their permit for the signage because it did not comply with the new act, Bill 96, although it's not even enforced yet. And so that was kind of odd. But then again, talking with the client, it's better to comply now to ensure that you don't have to change your signage a few years down the road.
So basically, you learned that municipalities will enforce the signage and not only the office.
Which is surprising. I mean, it seems to me it sort of it goes broader than their their role of applying their municipal regulation, but that's where we are. I guess everywhere you have some people that are more zealous than others. So I'll try to hurry up a bit. I've been taking a little more time. And another problem with the fact that the exception only applies to registered trademarks. No, hold on. Sorry. I was talking about the descriptive aspect of it. That's problematic. That if I can understand if you have a main trademark with some sort of slogan or descriptive phrase under it, that the government wants that little phrase to be in French. But that's not how the act is drafted. It covers any descriptive or generic term within the trademark. And an example I'm thinking of is Burger King. Now, technically in French, a hamburger or a burger would be en bourgeois. So wrapping my Whopper, would Burger King need to put the en bourgeois king? But because it describes the product that's being wrapped. But when you order your Pepsi at Burger King, well, burger is not a descriptive term for a soft drink, so then the exception could apply. Which a little personal comment here. I don't think the government thought of all these little implications when they. So that's why we're waiting for the rules to come out. Maybe all these discussions that we're having in the community will raise flags, and the rules will be a little more lenient. Now, just quickly on signage. Now, currently, the general rule for signage at a business premise that's outside, and that outside signage can be the trademark that's not in French can be used as long as there's sufficient presence of French, and usually what we see is like a generic term under it, like for example, home hardware, quincaillerie. As long as quincaillerie doesn't need to be as big as home hardware, but as long as it's visually, it's within the same frame, and you could see it at the same time, that's good enough. But now, I mean, in 2.5 years, the presence in French will have to be markedly predominant, which needs to be defined, but which implies that it's at least as big as, or it's bigger than, or more visible than the actual trademark. So I'm thinking of Canadian Tire, for example, which you've all seen, are huge stores with Canadian Tire spanning about the whole front facade of a 100-meter wide store. Now, will they need to build a second floor to put in like a French descriptor above it? So that needs to be seen. And also a small little nuance here, but still relevant, is the fact that the obligation to have a markedly a predominant presence of French with a trademark applies also for signage that is visible from the from outside. So not necessarily the sign is outside; it could be inside within. Just if it's just in the storefront, that I can understand. But technically, as the law is drafted, it could apply even to a sign that's at the back of the store. If you're walking on the sidewalk and you could see it over the shelves. So that's another thing that we need to think about. But then again, if that's probably the sort of thing where we could play on let's wait and see sort of thing. If I want to put my trademark on the back wall of my store, worst case scenario, in 3 years, you just add some words around it or whatnot. But you need to think about it. So as I said, I'm raising more questions than answers, and everything is context and detail. So there's hardly ever a straight answer that covers everything. Every situation needs to be analyzed on its merits, and on those words of wisdom, I'll pass it on to Eleonora.
Thank you, Pascal. And it is indeed words of wisdom, because it will be the overarching theme of my presentation. We are all trying to see how these provisions, the new provisions of Bill 96, will be applied in practice. In the context of banking and real estate, the provisions have been already in force for a couple of, a month for some of them, couple more months for others. So we are seeing some practical situations come into play, but it's we're going to have to play it by ear in the coming months and years with respect to this bill. So just as an introduction of the major changes that will affect banking and real estate practice, the bill now requires that applications for registrations of deeds and hypothecs and other registrable rights be drafted exclusively in French. This has different connotations, whether we're talking about the land register or we're talking about the RPMRR, or the Register of Personal and Real Movable Property. The documents accompanying an application for registration, if there are any, will also have to be drafted in French. If they're not drafted in French, they will have to be translated. And the translation, which will have to be authenticated in Quebec by an accredited translator, will have to accompany the application for registration. If there is no translation by an accredited translator, the person translating the document will have to provide a statutory declaration to the effect that the translation, that the person has the capacity to translate documents in Quebec, which brings the onus on the person that is actually registering. the application. And during my presentation, I will be using the words registration and publication interchangeably. In French, it will be publication, but in English, we kind of use both terms. When it comes to declarations of co-ownership, that's another act that will have to be drafted and published in French at the land register, as well as any amendments thereto. And the description of the fractions. This is not very different from what is being done in practice currently. Most declarations of co-ownership, especially in large projects, are currently drafted in French. There are exceptions to the rules that I just mentioned, namely for acts that will be published to amend or correct another act that was presented in a language other than French prior to June 1st, 2022. Those amendments can be presented at the register in a language other than French. Something that will be interesting for participants who deal with co-ownerships is that the registers and documents kept at the disposals of co-owners, as well as any document drawn up by the syndicate of co-owners to a co-owner, will have to be also drafted in French. And the Office québécois de la langue française is going to definitely see to the application of this rule now. So it is important to keep proper documentation in compliance with the bill. And another amendment that will kind of play a role in the real estate environment is that contracts of sale or exchange of a part or chiefly or whole of a chiefly residential immovable comprising fewer than 5 dwellings, or a fraction of that same immovable that would be part of a co-ownership will have to be drafted in French, unless the express wish of the parties is that they be drafted in another language. We have to keep in mind, obviously, that with respect to publication, it will still have to be done in French, and therefore there might be need for translation. Another point that I would like to bring up now is that leases, which do not need to be published in their entirety, they're just published by a notice of lease, they can still be drafted and signed in English. There is no requirement from the bill to draft them in French.
Unless it's a contract of adhesion.
Unless it's a contract of adhesion, the provisions relating to contracts of adhesion will come into force in 2023. We're still analyzing to see if commercial leases will be considered contracts of adhesion or not. It is a question of interpretation. It seems that they would be not necessarily considered so if there's a negotiation of them. Obviously, residential leases
what about if they're between 2 corporations? Would it still be a contract of adhesion, even if it's not negotiated?
It's still a controversial or like a subject to some interpretation, both in doctrine and jurisprudence, because it depends. There's several elements of a contract of adhesion, and everything has to be looked at in a factual.
And my mother is wondering, what is a contract of adhesion? She's very curious about that. What is that? What does that eat in the wintertime?
A contract of adhesion is a contract whereby a party is imposed a specific contract with standard clauses or not, but that person has a very little or cannot negotiate, same would have to accept the terms and conditions of same as is. So that's kind of, this is layman terms of what a contract of adhesion is, but that's hence why we bring.
And maybe to jump on Nancy's questions, for example, if you want to be a supplier for Walmart, the supply agreement by Walmart is definitely a contract of adhesion. There's no negotiation whatsoever.
That's it. So we'll be looking at that closely in the next couple of months, coming months, and especially when that provision comes into force in 2023. But for now, we're focusing on what's already in force and what we have seen apply in practice. And hence the next portion of what I wanted to discuss with you, which is what we have seen as the practice that is coming into existence with respect to registration, publication of different acts at the land register and acts at the RPMRR. So when it comes to the application for registration at the land register, as of September 1st, it can either be done in 3 ways. It can be done either by registering the full notarial deed, which will have to be done in the French language, either by registering an extract of the deed, which will only contain the French provisions of the deed, or by notice when the law permits, for instance, for lease agreements. So it would be a notice of lease drafted in French, registering the rights of the parties under that agreement.
Hey, Leonor, I have a question. In practice, is there someone at the office that flips the pages of the deeds and hypotheques to make sure they're all in French?
Well, whoever's working on the file will probably be making sure that everything is in French that needs to be in French. The land register does make sure if there's anything that's not compliant, they will refuse publication, which is a big consequence actually for our practice, because if ever you refuse publication of something of a right, you can either lose that right for the time being, or it can cause problems in a transaction. So good point. We are going to be making sure that the law is applied to the T.
And to that effect, yesterday somebody raised the question in contracts and deeds. There's sometimes a lot of Latin.
Yeah.
Now, how would that be considered French?
It must be translated into Greek.
The words that we say inter alia, or or references to English expressions.
That's it. Those we're going to have to be a bit more careful about. We'll try to remove any reference that might be published to English expressions. For the Latin, to be seen. I'll let you know if something gets refused. So for at the land register, so for deeds of sale, for example, there's been a practice, and there are practice groups currently talking to each other among the Montreal law firms, trying to figure out how to best manage each situation. For deeds of sale, the practice group has come up with a short form deed of sale that would only include the important elements that are required for publication, and that could be used, and it's obviously in the French language, that could be used and published in the context of deals that are in which the other documents are drafted in English, namely, the APS, Agreement of Purchase and Sale, that would be drafted prior to the publication of the deed of sale. The cancellation of rights, that's another important aspect for the land registry. Any deed of main levée, deed of cancellation, must from now on be drafted solely in French for presentation at the land register. This was something that we had been discussing even prior to the coming into force of the provisions, and we had already started as of June or July to draft deeds of cancellation only in French. There is a big, quite a long delay for publication of those, so we just didn't want to take a chance. Right now, the delay is about 2 to 3 months. When it comes to hypothecs, I'll start with the land register, but there's obviously implications at the personal register as well. For immovable hypothecs, we suggest that they be drafted and signed in French. It just facilitates, because then you just publish the deed in French and there's no concern, if it's possible. It's obviously feasible if the parties speak French or are bilingual, or if they're maybe represented by bilingual lawyers. It is easier to do that than in a context where the parties are Anglophone. In that context, there is another practice group that is discussing this matter. And although everyone is kind of doing different things. There is a certain consensus as to it might be a good idea to have a deed in English that contains the clauses for purpose of publication in French, whether it be in an annex, whether it be in the body of the document. But everybody is kind of doing their own thing right now, which works. There is no provision in the bill that prohibits the execution of an English hypothec. The only prohibition is the publication of English text. So everybody's trying to be somewhat creative on the approach. Eventually, we'll probably see some sort of cohesion in practice in the coming months and years. Some financial institutions, for instance, some have a bilingual hypothec model, some have really an English model, and they say just translate by authenticated translation. Some will say, well, here's the full hypothec in English, here's the full hypothec in French in the same text, and an extract is then published. It is important if we are representing institutions to make sure that we really follow their guidelines, which are currently being set up for this. At the Register of Personal and Movable Real Rights, the main distinction is that you do not need to publish the full deed, which brings a little bit more flexibility to the process. At that register, you register or you apply for publication with specific forms. For those of you who are, aware of what is used, RH forms for hypothecs, RE forms for partial discharges, and RG forms for example, cessions of rank. Those forms have specific parts that have to be mentioned, namely the name of the parties, and for hypothecs, for example, the description of the assets. So we will try as much as possible to be faithful to the English version of a hypothec. If it's signed in English, we're going to have to proceed with the translation of the parts that have to be published, namely the collateral. But it is also a best practice in the present context to sign movable hypothecs in French when possible, so that we can avoid interpretation issues when it comes to inserting language that has been translated into a form. Just like for immovable hypothecs, the ways of proceeding that have been applied so far are varied. They're similar. Sometimes you have 2 columns of the collateral description, one version in English, one version in French. The French version gets published. Sometimes it's in an annex. Other specific provisions may be also translated in French, such as the authorization to collect debts. What is important to retain here is really that the translation has to be done correctly, because there could be problems of interpretation in the future. In an insolvency context, for example, the validity of the publication could be questioned if done incorrectly. It's not just because the publication has been accepted at the RPMRR that it is valid. The validity of the opposability to the third parties is the fact that the publication is in compliance with the bill, namely. So this is an obligation of result. It's quite important to make sure that registrations are done properly so that the parties are properly protected and their rights are preserved. The consequence of any issue with the translation or with the filing could be that the RPMR or the land register decide not to accept, and they refuse the publication. We already spoke a little bit about contracts of adhesion, so that pretty much covers the real estate and the banking portion of the.
So we'll pass it on to Sean.
Okay, very good. Nouveau recours civil pour une. Okay.
Yeah, maybe mention that.
I wasn't even able to read it,
Oh,
but
okay, sorry.
don't worry about it. Just bring it up verbally. I can. It's early in the morning. I can
Yeah.
barely read. I'm being told I have 2.5 minutes. So I'm exaggerating, but we're gonna try to keep it as short and sweet as possible. It's a pleasure to be with you this morning.
You're always sweet. Short, I'm not sure.
Oh, I like that.
Sorry about that.
I like that.
We're quite good friends.
That works for me. What am I here to talk to you about? Litigation, but more specifically, civil procedure. It might not seem like the sexiest topic in the world, but it's pretty darn important for you and for me as well. And what I would tell you is that essentially this statute, this law, is not significant from a quantitative perspective when it comes to civil procedure, but it is meaningful from a qualitative perspective. And what's interesting is that the procedural aspect of it, which occupies relatively little room, very limited amount of geography in the statute, is actually drawing an awful lot of attention and generating some litigation, perhaps not surprisingly. What is the thing that you have to remember and walk away with? What is the biggest change from a litigation perspective, from a civil procedure perspective? It's the fact that if you are going to file a procedure, or what the statute calls a pleading, into the court record, it must be accompanied by a translation. And not just any translation, my friends.
Certified one.
You cannot just put it into Google Translate and wow, there you go. By the magic of the interwebs, you have yourself a translation. No, you need an official translation. And what that means is that it has to be certified by a translator who is a member of the Order of Translators. It has to be a certified translation. And I stopped there for a moment to say a few different things. Number one, this does not apply to you if you are, I hate to use this term, natural person, an ordinary Joe or Jane. So an ordinary person would not be affected by this change. Who would be affected, however, are legal persons, that is to say, businesses.
Unless the business is run solely by an individual.
I'm not sure that I wouldn't agree with that.
You
I don't
wouldn't?
know that that's the case. I think that that's I wouldn't agree with that.
Okay.
I think that anything that is a business, or that is an institution, or that is a nonprofit organization is targeted by this. And so it affects not only those big companies out there, but some of the smaller not-for-profit organizations as well. And this generates problems. It generates logistical problems in the first place, because what happens in litigation when we are drafting our pleadings and our procedures? Of course, we're extraordinarily diligent. We work very hard, but quite often these things get finalized right up until the last second. In my practice, I have the privilege and the pleasure of working mostly with in-house counsel. And so in-house counsel partner with us. They provide us with enormous amounts of insight and participation. Quite often, these in-house counsel are not in Quebec. They're outside of Quebec, and we're dealing with them in English, and the pleadings are in English. And so how do you go about translating something that is being created right up until and finalized right up until the last moment? So there is that logistical difficulty. Beyond that, there is the whole question of the translator, him or herself, because the fact is there are not 100,000 certified translators in Quebec. There are a very limited number. And so there is an insufficiency, I would say, of resources. So this is actually a big problem, or a big issue logistically. Another few changes that you should keep in mind, which are a little bit less germane for us, but nonetheless quite interesting from a litigation standpoint, is the fact that judgments that are going to be rendered by courts in Quebec, if they decide the merits of a dispute, and if they are of public interest, if they're rendered in English, they must immediately be accompanied by a French translation. And immediately, maybe I'm old-fashioned or a little too simplistic, means exactly at the same time. So this is imposing something on the court system. Again,
and will incur even more delays that we're having right now.
Arguably, yes. And there are already these delays. And so there's this whole issue of access to justice, which is such a huge theme. And
But Sean, I would
yes.
point out that that's already the case at the federal courts.
Yeah.
All judgments needs to be rendered in French and English at the same time. And in practice, what happens is there's like a draft judgment that's circulated, and then it takes, they take the time to translate it. But it does indeed delay the issuance of the official order.
Yeah, interesting. And also, I think with the federal court system, its bilingual character is baked in, if I can say, from an institutional standpoint, whereas that's not quite the same thing with the Superior Court, certainly not the same thing with the Court of Quebec. So that is an additional change. If an arbitration decision or a foreign judgment is to be recognized in Quebec and it was rendered neither in English nor in French, there must be an official French translation, which is a little bit less surprising for our purposes. Now, will this change things? From a class action perspective, because that's sort of my own personal area of expertise, I realize I'm going outside of the 2.5 minutes, but don't worry, I'm going to draw it in very quickly. See people getting nervous, or maybe they're not nervous at all. They're very happy. They're very satisfied. I hope you are too. Because from a class action standpoint, again, who are the people who are bringing these class actions? More often than not, they're not legal persons, they're natural persons. And so they can file their class actions in English or French as they wish. And to the extent that a legal person does bring a class action forward, typically these are French language organizations like Option Consommateur. And so that is not going to change anything. A couple other important points that I want to make. Number one, what does this deal with? It deals with the pleadings themselves, the procedures themselves. It does not affect exhibits. And that's a big deal because a procedure could be supported by anywhere from 1 to 100 exhibits. And so the cost of translating all of that would be enormous, but that is not required. And the other thing that I've noted down that is quite important is that when you actually go to court and you make your arguments, your oral arguments, you can do so in either language. Your written submissions, I think, can also be in either language because an outline of argument is not a pleading. So I think there too, there's a little bit of a loophole. I don't want to give too many ideas to our legislators out there, but there's a little bit of a loophole.
And same with testimony.
Yes, absolutely. Same with testimony. Yes. Now, not surprisingly, there have been challenges to this. There are court challenges that are pending right now. There are at least 3 different cases that have been brought before the Superior Court. The English Montreal School Board is challenging this because, of course, Bill 96, which is now law, does not just affect civil procedure or the various matters that we're talking about today, labor and trademarks and all of these and all of these very important things, hypothecs, contracts of adhesion, all of this important stuff, but it also affects pretty much everything else, including education, including health, including various other things. So Montreal School Board is involved in this, in challenging the statute. There's an indigenous group or indigenous groups that are challenging the statute. And there are members of the Quebec Bar, troublemakers that they are, who are, I'm kidding, they're doing the Lord's work, I'm sure, who are also challenging this. Now, what's interesting is that when the government adopted this statute, it invoked what's called the notwithstanding clause in order to make it charter proof. In other words, in order to ensure that arguments based on either the Canadian Charter or the Quebec Charter, for that matter, could not be brought against this piece of legislation. However, not everything is contained in the Canadian Charter of Rights and Freedoms, as important as that document is. There are other aspects of the Constitution that also come into play, because when you look at, for example, certain institutions like the National Assembly or other provincial legislatures, when you look at the courts and these important institutions of our society, there are provisions in the Constitution Act 1867 that also apply. And really the crux of the argument against against the legality of these aspects of the new law are rooted in Section 133 of the Constitution Act 1867. I still have a copy of this very important document.
Yeah, I noticed always have it with you.
I always have it with me, whether or not I'm giving a webinar or not. I always have it with me just in case. And I just wanted to share with you, it's one sentence, but this is sort of the basis of the challenges that are being brought, or one of the bases. Either the English or the French language may be used by any person. Interesting there. I'm just stopping for a moment. It doesn't say any legal person, any moral person, any person, or in any pleading or process in or issuing from any court of Canada established under this act, and in or from all or any of the courts of Quebec. So that seems pretty clear, but in any event, I'm not weighing in on it. I am by no stretch of the imagination a constitutional expert. But what is being put forward is that, look, there are aspects of this statute that are unconstitutional, that create inequalities with respect to the two founding languages from an institutional standpoint, and that pose problems, as you said, Nancy, rightfully so, with respect to access to justice.
Exactly.
Now, what is it? So she's more certain about it than I am. I'm just trying to give you a dispassionate account.
Well, Judge Corriveau agreed with me.
Exactly. Yeah. Well, hold on a second. Flag on the field.
Access to justice.
Let's not go too far. So, but yes, the what's interesting, the interesting development, the juicy development, is that there is a new decision that was rendered on August 12th, 2022 by Justice Corriveau, Chantal Corriveau of the Superior Court of Quebec. And the issue, though, this was not a decision on the merits. In other words, she did not decide that either these provisions are or are not constitutional. However, the members of the bar sought to stay the application of that very important provision that deals with the translation of legal procedures. And what Justice Corriveau decided is that, yes, the applicants have made out a sufficiently serious case that for the time being, and until the merits of the dispute are fully and finally decided, I am prepared to stay the application of these provisions, because she said, look, there's a serious issue in dispute. It could result in irreparable injury, and there is a very big access to justice issue.
So for now, even legal, moral persons can file their pleadings in
Moral
English.
or immoral, doesn't matter. You can file in English or French. And I will say that, again, because of the logistical aspect of it, leaving the legality aside, the logistical aspect of it was really a complicated problem for us. So for the time being, and probably for several months, we're not going to have to contend with that. I'm just going to end on one larger quasi-philosophical question, and that is, should parties seek to escape the jurisdiction of the Quebec court because these provisions may or may not come into effect? Should we litigate elsewhere? Should we arbitrate elsewhere or according to the laws of other jurisdictions? And what I would say are two things. Number one, of course, to a certain extent, this is outside of your control because you are not always on the plaintiff side. Quite often you are on the defense side. And as defendants, you don't always have the choice of where you go, where you must appear to defend yourself. So you're going to have to deal with Quebec, whether you'd like to or not. Beyond that, even if these provisions were to come into effect, and I think between us, let's just speak between us, the fact that Justice Corriveau granted this stay arguably is a little bit of judicial foreshadowing. So I would not personally be astonished that these specific provisions are found not to be constitutional. Again, I don't know what the outcome will be. We cannot say, but I think that it's at the very least a 50-50 proposition, probably better than that it will be struck. However, there are many things that recommend our courts as well. And one of the big features that we have that other jurisdictions don't have is that here, there is no such thing as a civil jury. So, if your concern, for example, is with huge punitive awards,
Runaway damages.
runaway damages. Actually, Quebec is a very, I think, reasonable jurisdiction. We have a commercial division to the Superior Court. We have now a class actions chamber. We have a very good judiciary. And so I think, while Quebec is not perfect, point me to the jurisdiction out there that is. Would it be better to litigate under the laws of California? Would it be better to litigate in Ontario, even where there are still civil juries? I'm not so sure. So while I think that these proposed changes are meaningful and significant, I don't think that they fundamentally change the nature of the way that civil litigation is done in Quebec or the way that litigation is prosecuted in this province or defended, because guess what? In class actions anyways, we just do defense, and we probably, well, hopefully don't defend too many of you, but we're always honored to do so when necessary. Thank you very much.
Sean, do you want to just give a couple of words on the new civil recourses that are available under the charter as it touches on your subject?
Well,
Very briefly.
Let's just put a pin in that. I'm going to look at my notes and then I'll get back to you on that question.
Thank you, Sean.
You're welcome.
Always a pleasure to do a webinar with you.
I know.
You and I always gel well. So anyway, I'm going to speak to you today about the language of labor relations. Since we're doing an update on the webinar that we did back in the summer, I want to tell you something. And one of the first thing is that there is no changes between what was proposed on Bill 96 and the law that was actually adopted. So everything that we spoke to you before, everything that you've heard before the adoption of the law is in force, now in force, except for a few provisions that are in force in 2023 and 2025. So the purpose of what I'm going to talk to you about this morning is to basically tell you of some of the issues that we've encountered so far with respect to the application or the potential application of this new law. One of the issues that we've encountered is some of our clients do purchase or purchase training modules that are solely available in English for their employees. It's mostly on highly technical aspects, and usually it's not going to be, and I say usually it's technical aspect because it has to be something that is not available in French. The current law says that training material has to be provided in French to employees. So that's why it is an issue. I think in the application, what we're going to be seeing is that the OLF or the office is going to look at it at the same way as they're doing for software right now. So for software or tools that are provided to employees, they have to be in French. Unless there is in English, it's only available in English. So if your training is only available in English, I think that the OLF will probably accept that as an exception. So that's an issue to be followed, but make sure, do your due diligence that the training that is offered to you by the provider is really only available in English. And that would be Article 41C of the Charter of the French language. Now, we have a lot of questions relating also to job postings. As you know, this is one of the big changes that you are encountering in your everyday life. We all know that we have a shortage of manpower, so we do a lot more job postings than we used to. So on a day-to-day basis, and you have to look at Article 46 and 41 of the Charter in order to see what you have to do in order to make your job application published in French. You have 3 criteria that you have to look at. The employer, you have to assess actually the needs for, if you're going to request that English is a requirement for that position, that's where it comes into play. You have to actually assess the real need for that position for it to be, for the English requirement. The employer must make sure that the language knowledge already required from other staff members is sufficient for the performance of those duties. That has always baffled me. I'm sorry to say with this type of expression, but what are they going to say? That the other members of the team have to speak, that already speak English, it's already sufficient, so that position doesn't need to speak English. So basically, other people are going to do the job of that person. What are they going to be entitled up to a premium? It's very, that and its application is going to be very difficult to discuss. Also, the employer has to restrict to the minimum the number of positions involving those duties that requires the knowledge of a specific knowledge of another language than French. We always speak of English, but it applies to other language.
Including Latin.
Including Latin. An important thing, however, is that at the end of a paragraph, and that's why we always say this is of application looking forward. As we know, these type of legislation have no retroactive application. So this applies only to, as of June 1st, 2022, to the job postings that you're doing going forward. So that's why it says in the bill, it says, without restricting the scope of the first paragraph, basically, it does not impose on the employer an unreasonable reorganization of the enterprise, so of the business. So basically, you don't have to reorganize your job positions, your job in order to fit this new requirement. This brings me to the other issue where it comes into play. As you know, your company basically has to generalize at all levels of the business the use of French. So the other issue that we're encountering right now is our clients that have to renew their Francization certificate. So when they renew the Francization certificate, they look at all levels of the business and it has to be generalized. So we're wondering right now, and we're looking right now, is that if you're not meeting the generalized criteria, are they going to look at your job descriptions that were adopted and where you have an incumbent, where the person is already in the position, and that was pre-Bill 96. So remember, this is an issue that you have to look at, and you should discuss with your counsel or with your Francization committee. And remember that you don't have to do an unreasonable reorganization. So that's one of the issues that we're looking at. Also, one of the issues that we have are the workers who only speak English. So, or another language. We have this with the global, hiring that we have right now, and the difficulty to hire employees or finding workers. A lot of clients are moving to employees who actually do not speak French, at least at the beginning. So, what you have to look at right now on these type of hires now is that these type of you have to do your due diligence in order to prove to the OLF that you did try to find someone that spoke French and that you have been unable to fulfill that position. So you have to build basically a case file in order to be able to hire someone who will not speak French. Of course, if they're willing to take French courses, it will help. But at this point, and that's where comes Francization Québec, which will offer courses of French lessons to people who do not speak French in a business. There's even going to be some, I've heard there's even going to be available some funding for this for the businesses. And you could also actually do the funding for this through the training for the percentage that you have to do every year.
Hopefully they won't dig into the resources for translators for that job.
You still have that difficulty of translation because, and that brings me to the other issues that we have, Pascal, actually it ties in very, very well, is the offer of employments that have to be in French. That issue is less present now. It was really present at the beginning. And now pretty much all employers have adopted that if it's not a negotiated contract, it becomes a contract of adhesion. And if it's a contract of adhesion, the employment contract has to be in French. It's rare that an employment contract is not a contract of adhesion. So I would err on the side of caution here. And that's what employers are doing. They're either doing a side-by-side French and English, or they're providing the English, the French and the English version to the employee. And then the employee will send you a confirmation in writing, telling you if you see if he's wishes to sign the English version instead of the French version. And this is important. Why? Because if you don't do this and it's contested afterwards, your contract, your offers of employment or your employment contract will be null and void. And that will null and void everything in your non-compete clause, your non-solicitation clause, your IP clauses, which are very important, and the entire contract will be put in jeopardy. Also, another issue that we have a lot is the meetings of management committees held in English only, because the participants are either outside of Quebec, or some of the participants at a high level mostly don't speak French. So what the law tells us is that your communications with your employees and your must be and then was in French, and your written and your every employee has the right to work in French. So that poses a lot of issues right now. Right now, what we see is that it's pretty much business as usual, but it's on the radar of a lot of employers. And even some of the employees who have their boss sits in the US or sits in Ontario, and they have performance reviews, they have their right to have a performance review in French unless they requested it's in English. So that's another issue that we have right now. And we don't really know how the OLF was going to handle it, because if the employee makes a complaint, I think mostly you'll have a right to do it in French, and you'll have to provide a person to do the meeting in French. But right now, at an I management level, for meetings where there's a lot of group of people, we don't see a change in the way business is being conducted. Of interest also is that, and we haven't spoken a lot about that, but an interesting point, and for you who work, every day with the Labor Standards Act, know that everything goes to the Labor Commission, and Labor Commission provides representation to the employee for free, and the employer, of course, has to pay for their own lawyers, their own representation, and everything is referred, if it's not resolved at the commission level, to the administrative tribunal. It's the same here. They've replicated basically the mechanism of the Labor Standards Commission. And so the complaint is made to the commission by the employee within 45 days of the event he wants to complain about. And then afterwards, if it's not resolved at the commission, it will be referred to the administrative tribunal with a representation for free. A little difference here is that the commission can actually name a third party, which is not involved in the issue, to try to resolve the issue at the outset instead of going through the legal process. So that's one thing that's interesting. How is that going to be? How is that going to work? We actually have not much of an idea, but it should be interesting to see. It's another position. That's it. One of the things that I want to talk about at the end also, which is very interesting to our clients, is that will the OLF change their approach that we've seen prior to the Bill 96 in the application of this with businesses? The OLF has always taken the position of what we call flexibility, and they're continuing to do this. One of the other things why also they're flexible is because there's also a shortage of manpower at the OLF. So we have the situation where some franchisation certificates have expired for a few months, and the OLF is not even knocking at the door of the employer. What I tell my clients is that be proactive, start your own analysis of your language situation in the business with the new rules, do your due diligence. And so when they come knocking at your door, and keep, you're ready, and keep the communication going with the agent who's not ready to look at your file right now, and tell them that you're working, keep in contact. put everything in writing, especially because you don't want to be told at the end, well, now you have to do it quickly when you're not ready. So the name of the game is, do your due diligence, know the law very well, explore the gray areas, and just be ready for the new rules. Thank you very much, everyone. I think we're ready for questions.
Yeah, or is Sean able, like the good litigator that he is?
I
he's
have,
pose
yeah,
a
thank you.
question, a surprise question.
Always a pleasure to be. No, I have actually a few things that I think are important to mention, and maybe it's already been stated, but we're also expecting a regulation.
Yes.
Because as you've probably been able to assess, there's an enormous amount of question marks that are raised by this legislation and a lot of gray area. And I think that the devil's in the details, and many of those details will be found within this regulation, which will hopefully spell some of these things out. In terms of not imagining that the provision that I talked to you about a moment ago regarding the translation of pleadings were to come into effect. So imagine that were to come into effect. What would be the result of that? The result of that would be that the greffier, the court clerk, would not accept the pleading. And that could be a big deal because maybe you miss your statutory delays. So that could be a big deal.
Which
oh my
are
goodness.
of an urgent matter.
You know what? And that's actually a very, very good point that I didn't think to mention before. But, of course, any procedure requires working very closely with the client, often right up until the last second. What do you do if you're dealing with an emergency situation? Does it make sense that same rule would apply? Would that mean that therefore the way to do things is just to proceed in French and then tell your client, well, look, trust me, everything you're telling me is going straight into
and then
the
he's going to
official
be
French version
on what's written in French that he doesn't understand.
I
think that's why Judge Corriveau was talking about access to justice.
I think she probably was talking about it for that reason. So that's those are a couple of things I want to mention. Again, we said that this is, the nature of this statute, it is not a self-contained regime. It is a statute that goes and modifies various other statutes, including the Code of Civil Procedure, maybe even the Constitution, and the Civil Code and various
and
other.
has impact on the Labor Standards Act.
That's right, the Labor Standards Act and various other statutes and procedures.
Collective agreements also,
Collective
because
agreements.
all the provisions are deemed to be incorporated in your collective agreements that are actually in existence.
So so among the various statutes that are modified by this bill or this act is also the Civil Code. And you mentioned before causes of action. And it's true that, again, this is a statute with teeth. So it's not just words on a page. And, what happens if, for example, there's a violation? Does that, and let's say, obviously, the state, there's a commissioner that will be inquiring into things, but the state does not have its eyes everywhere. So if you are a party, for example, and you see that there's a violation or someone is claiming that you violated the statute, well, there will now be provisions that are contained in the Civil Code that will allow you to contest that and to seek a cessation of that violation. So that's a new cause of action that has arisen out of this statute. And in instances where a particular provision that has not been translated into French by a certified translator causes an injury, it is possible in some circumstances, if the criteria are met, that you can seek an annulment. So that can have meaningful consequences as well. So this is not just these are not just theoretical changes. These are changes that can result in new remedies. And that can civil remedies and statutory remedies in some cases, and that can result in dollars and cents.
Yeah, if you look at what we were talking about with respect to penalties, because in the law there is a lot of penalties that are now, because before we said the charter, the previous charter didn't have much teeth. Now they put a lot of teeth into it with the penalties. But however, usually that's why I was talking about the approach of the OLF on this, which is very important, because before you get to the penalty, you're not just going to receive a penalty in the mail. You'll get the complaint. It's going to be investigated. I think think they've always adopted they give you the chance to remedy it prior to this. And then it's only after that if you refuse to remedy, that there will be a penalty.
Yeah. And I don't know if it's fair to say so, but I think that the thrust of the legislation, rather than being punitive, it's about modifying behavior, and it's about deterrence, because
I agree.
if you look at some of those penalties, like one of the new aspects, some of the new teeth, is that in instances of repeated offenses, you will have an escalating scale of penalties. But again, it's not as though these things come into effect automatically.
Correct.
I cannot imagine that the OLF is going to radically change its approach. And maybe the regulations will provide added insight as well on how that aspect is meant to be dealt with.
Thank you. So we'll move on to questions, and then this will surely have the pleasure of discussing this a little further. So question number one, is the Quebec government is the Quebec government assisting the companies in sharing the costs associated with changes due to Bill 96? Advise if the employer has any legal remedies. Thanks. I think, in other words, is if you need to modify or implement new procedures internally or change signs and posters, is the government supplying any funding for that? I think the answer is no.
The answer is no. However, the Ministry of Labor has a program that employers can reach out which specifically for HR. And there's a lot of it. So you could look into this program and find it on their website. If you need more information, I could provide it to people who reach out. And it's possible to get some funding with respect to some HR issues. This could be actually probably qualify, for this.
Yeah, but if you need to translate documents and this and that, no,
not for pure translation. No. It has to be more that if you position it more like a assistance for your HR, and it's only available for small businesses.
Right. Next question. A few of our applications, I think, is IT applications from external vendors, like internal ticketing systems or cybersecurity training, are in English only. Are we okay that they are in English only? And I guess that would be training for employees. So that goes to Nancy again.
Yeah. So that was the first point that I raised. The law actually, and the way it's written, says that any written training material has got to be provided in French and in English. So in both languages, if you want to provide a language other than French. However, as I said, this proves a difficulty of application, and we're thinking, it's not set in stone, that the OLF will probably go with the same, I would say, the same approach that they do for software, which is if you're able to prove it's not available in French, that you will be able to conduct this in English only.
Question for Elliot. Well, it starts with Eleonora. We'll read the question and then we'll see to whom it goes. Eleonora mentions that practice groups came together to work on a short French form of deeds for publication. Perhaps not ideal for notaries conducting title searches in the future, ? To your knowledge, are there talks about contesting these provisions in the law? Do you agree that the concept of translation may cause potential conflicts between the parties where, for instance, an APS drafted in English and a registered translation are not identical essentially?
So I'll go one question at a time. Effectively, one thing that is being talked about and the Chamber of Notaries, La Chambre des Notaires, is looking at closely is what would these new provisions entail when it comes to title searches and title opinions? Because obviously, if you're registering just a short form deed of sale, there are certain aspects of the transaction that notaries may not be able to see on title, and they might need to request the document that is referred to in the deed of sale. So that is something that is being discussed. What are the best practices? For now, there is not much in terms of another way of proceeding than to proceed with short form deeds of sale when it comes to transactions that are mostly where the documents are mostly drafted in English. This is not very different, though, from what was done in the past in English transactions, where there was a more extensive agreement of purchase and sale, and what we would call a bare bone deed of sale, in which the only terms and conditions that were mentioned in the deed of sale were the ones required for registration. The next order talks about contesting these provisions. So there's nothing yet that we have heard of in our practice. However, and we were talking about it yesterday, there are provisions that are problematic in terms of protection of the parties' rights. Here we're talking obviously about the publication of rights. If something goes wrong, someone loses their rights. So there could be potential for contestation, especially because there's not that many exceptions that are put into the law. But again, this is speculation, unless you've heard something on your end.
I really
There's
haven't.
not-
I've heard nothing.
So it's we haven't heard of anything yet.
And then the last question is really interesting. Essentially, if there's a divergence between the actual contract or deed and the published translation, which one prevails?
Yeah.
Well, that's,
I guess it depends on who's trying to benefit. If it's a third party that's trying, he has the publications. Probably it could be the translation, right?
It could be the translation, and hence the issue, because we do not have a practical example of this going into court for interpretation
and the
purposes.
issue, I think, also is the fact that don't forget that translators are not attorneys or lawyers
Exactly.
or legal people.
Exactly.
And so then the cost even goes higher, because the translation is going to have to be verified that it's actually reflects the legal document, which is in English, and if you do not reread the translation and, bulletproof it, there is a big issue.
Right.
I know we have this issue for employment contracts because I receive translation from translators. I'm not saying that translators are not good, but they're not specialized in this.
Right.
And then you receive the translation, and the translation does not use the words that we use for employment contracts.
Yeah.
Yeah. And
100%.
the other question too is, does the original version benefit from a presumption of correctness that the translation does not?
Correct.
So that's the other thing. So what do you do in instances of inconsistency between the two? Regardless of what that document is, a pleading, same thing.
Yeah. And I mean, it is an issue, because when you think of hypothecs where you're charging assets, sometimes the list of assets is 5 pages long. And what if there's a discrepancy between one minor word that can make a difference for when you're in process of either insolvency of actually realizing on the asset.
So I'm actually surprised, thinking when I hear everything you said, that it hasn't been contested in the same way that the access to justice has been contested with the pleadings.
Yeah, I think it might be because the whole pleadings thing, it's something that anyone can sort of grasp fairly readily. And it's so fundamental, but absolutely, it's sort of these same issues are replicated throughout different ramifications of the statute.
Yeah, and I mean, right now, maybe we haven't seen so much contestation of this, maybe because right now we're in the process of registering and publishing the deeds.
Right.
So let's say a deed of hypothec, usually there's, the term for a loan is quite long. The term for a lease is usually several years if you're starting to register now. So I don't know if we would see the consequence for a party right now
at this point in time.
At this
That's
point.
interesting.
So that's
It's a bit the same thing, because I'm surprised. One of the things that the bill did is actually expanded the jurisdiction to businesses that are under the federal code of labor. And as we know, usually the Quebec government would not have jurisdiction on federal businesses. And we haven't heard of a formal contestation right now. So I'm a bit surprised by that. Will it happen when actually the OLF tries to assert their jurisdiction and one of the businesses is going to say no? That's to be seen. But actually, I agree with you. We haven't seen it so far, which is a bit surprising.
Yeah. And just to go to the APS questions, the agreement of purchase and sale, just to go back to it, it's also another possibility that we're foreseeing now is, in order to ensure that the parties agree somehow to the form of deed of short form deed of sale, we might potentially start putting it as an annex to an agreement of purchase and sale. The French version that would be agreed by both parties, which is kind of what we're doing with hypothecs right now with the charged assets.
So the next question, we're having technical problems. The screen is blank, but I read it before it went blank, and I remember the question. The question was, and I'm going ad lib, if a judgment is rendered in English but needs to be registered, does it need to be translated? And I think that's sort of a moot question because the judgment can't be rendered unless it's with certified translation. So I guess that judicially certified.
The distinction is this, and that's why I think it's sort of germane, is that only decisions that would decide the merits of a dispute or that are of public interest, whatever the heck that is, need to be translated immediately.
So if it's an interlocutory judgment rendered in English that needs to be registered, then you'll need to have it translated and pay for the translation.
100%, because effectively the answer is yes, you do need, this is the documents accompanying an application for registration, which include judgments,
which is kind of
to be translated.
Including a judgment rendered by Quebec court.
Yes.
Wow, that is something. That is really
because sometimes you have to publish a right by publishing the judgment that provides for that right.
Brings me to my question. What about a judgment from a foreign jurisdiction?
That's an interesting question. We would need to see, because at that point, it still needs to be in French to pass at the register. Now, there's no exceptions really to this rule that have been seen in this law.
That being said, I think there's another little loophole that maybe you could take advantage of, because according to the legislation, anyone, not either party, anyone can ask that any English language decision be translated in French at the expense of the state. So all of us, with our tax dollars, but that rather than actually hiring your own translator to do it, the problem is, how long is that going to take?
Going to take 6 months, a year.
And in any event, that provision that requires for the translation of the judgments will only come into effect in 2024.
Correct.
So, but that would be a potential solution.
And I was speaking to a colleague of mine who does this type of publication often, and he says that there is actually a translation department at the courts that could do this type of work, but it's very small, and
overburdened, and absolutely,
and suffers from a shortage of manpower.
Absolutely, absolutely.
Are we back on track with the screen? Sorry about that.
Do you guys always look this sharp? The answer is yes. We always dress for the occasion. We look good.
Do we always
pride
have
ourselves
this much
on that.
fun? The answer is yes also.
Yeah, absolutely.
There's no exception built into the law. So basically it will become a question of that. If the use of French is generalized at all level, and you have one manager that speaks English and is outside, you'll still be qualified with the law, unless one of his employees raises the fact that he has a right to be addressed to in French.
What happens if the judgment drafted in English needs to be registered at the letter register?
No, we just answered that one.
Yeah, we answered that.
Would loan agreements between sophisticated corporate entities potentially be considered to be contracts in addition?
So would loan agreements between sophisticated entities be considered potentially contracts of adhesion? One of the exceptions in the law talks about loan agreements. So the exception talks about loan agreements with the administration, but it kind of makes it a generalized statement about loan agreements. So there might be it might be a non-issue actually, because loan agreements will not be considered a contract of adhesion under the new provisions that will come into force in 2023.
So next question. Okay, further to my first question, does all invoicing, shipping, documentation, and communication have to be, don't move it. Okay, further to my first question, does all invoicing, shipping, documentation, and communication have to be solely in French, or is there exceptions to this? Well, solely in French, I think the answer is it could be everything could be bilingual in these circumstances, but does French need to be
Predominant.
well, no, it depends. And then not necessarily on the invoicing. You could have a perfectly bilingual
Yes.
invoice. And then it depends, I guess, if your client is a consumer or not. And I mean, that's a very broad question, and there's a lot of depends on this and that. Does anybody want to elaborate a little more?
Well, what I've seen with respect to this, because I do the labor relations and things like that, but when you do a renewal of franchisation certificate, you look at all aspects, and that's one of the aspects that the OLF looks at. What I've seen is that basically if your invoices are in both languages and your French is the first language on the invoice and English is after, they won't raise an eyebrow. This is not usually an issue.
So Article 57, so Article 47 of the bill mentions that invoices, receipts, and releases and other documents of that sort have to be drafted in French. No one can transfer a document other than in French unless its French version is as available or as accessible to the person sending it or requesting it. So it's
which one? Thank you. Okay, thank you for hosting this webinar. Well, it's our pleasure. As a supplier as a supplier of materials into Quebec, both from other parts of Canada and the US, what is required immediately? That company has all technical information, SDS, marketing information, all in French, along with a French version of the website. In addition, all Canadian-made products have bilingual labeling associated with packaging. We just want to ensure we are compliant. Well, again, this is a very broad question, and there's a lot of exceptions, and it depends. But I mean, generally, I think that's very good. Website, that's a good point. People ask that question quite often. Although in theory, the OQLF takes the position that any business that targets or does business with Quebec consumers has to have a French language website. That's in theory, that's their position, but in practice, their position is that they will not take any action against foreign entities, and by foreign I mean out of province, that don't have a French language website. However, as soon as you have an office, a store, or something, the actual physical presence in Quebec, websites need to be translated, bilingual versions.
Yeah.
Is it true? Okay. Is it true that in Quebec, we need to confirm if someone wants to receive communication in French, even if they are speaking French on a French website, and request additional info? We need to ask which language.
In the context of employment, no. What you need to do is that if someone wants to be addressed or communicate in an employee in English, you need to obtain a confirmation, and you need to obtain a request and document your file. But in order to be in French, no.
Next question. Has the OLF hacked your computer system? We don't know yet, but we're investigating.
We're 9:29. So thank you for bearing with us this morning. And
through our technical difficulties.
Yes, sorry about that. And hopefully, you'll join us again in a year or so once, this is a big ball that's rolling and it's gathering steam. And I guess we'll have more to say on many of the questions people asked that I don't have answers yet in the relatively near future.
Thank you very much, everyone.
Thank you.
Thank you.
Thank you very much for being with us today, and we hope to see you soon.